While our nation continues in upheaval, there seems to be measures to understand what some next steps could be. I have found one source of a cohesive set of demands that outline practical changes that can be taken. This is taken from the National Association for the Advancement of Colored People, otherwise known as the NAACP, and it looks like a worthwhile place to examine those conditions that they're laying out. So let's ponder those together and see what we can come up with there. Welcome to this June 5th edition of PNDA Ponderings. This is Phil coming back at you again with some information that you should know about and ponder on. Before we get to the topic at hand, I'd like to take a minute just to say something. We really need to come together. If we're looking for lasting change, vilifying people and people groups is what we're fighting against. And yet, time and time again, we're seeing social media posts and public discourse making blanket statements about people groups and people. Look, if you've made degrading comments about all black people, you're obviously racist. But the same spirit resides in those who are making degrading comments about all police, or all white people, or all whatever people. It's one thing to call out injustice. It's another thing to use the platform of justice reform while using the same divisive spirit that is what's fostering racism. If our ultimate goal is the unity of all Americans, regardless of race, gender, socioeconomic conditions, etc., then it will take a spirit of compassion and love to get us there. Judging a group based upon their worst examples help to prove a point, but it doesn't help to build that bridge towards a future that is worth having. The spirit of dissension only leads to war. So check yourself and ask the question, is what I'm saying or doing promoting war or promoting peace? Now, back to the topic of today's pondering. Our nation, our people, are clearly asking for reform. There clearly needs to be something done. There is unrest because there hasn't been lasting change that solves the issue of systematic racism when it pertains to the justice system and law enforcement. So the NAACP's Instagram post seems to be the one source that I found outlining in clear terms what are some demands that would help to break down this issue of systematic racism in the judicial system and the law enforcement systems. So let me pull it up on screen and read it for you all. Let's take a look. So an update from the NAACP. Our oppression has reached its boiling point. The uprisings we're witnessing in Atlanta, Chicago, Dallas, Minneapolis, New York, Oakland, Washington, D.C., and many other cities across the U.S. are a direct consequence of the racism, bigotry, violence, and subjugation against black people that has festered in this country for far too long. The murder of George Floyd and the subsequent lack of accountability by the police has set into motion what can only be described as a moment of reckoning for our nation's conscience. How we become the land of the free depends largely on what happens next. As we continue to advocate in the memory of George Floyd, now is the time to ask ourselves, what does justice look like? Yes, we all want the officers involved to be immediately arrested, tried for murder, and convicted, but justice for George Floyd also means bringing an end to the criminalization of black skin. It means holding police departments accountable for their role in terrorizing our communities for years. It must mean a complete and thorough policy reset so that no black person is ever put on trial for their own murder, as we saw in the case of Trayvon Martin, Eric Garner, Sandra Bland, and Michael Brown. To ensure our survival as free black people in this country, two things need to happen. First, what has now become clear to the world is the ongoing practice of police brutality, specifically against the black community, is not only a civil rights issue, but also a human rights issue. The NAACP is calling on the United Nations to step up and classify the mistreatment of black people in the U.S. by the police as a human rights violation, aggressively calling out the U.S. government in the process, and impose sanctions if necessary. Secondly, we need sweeping police reform, federal legislation mandating a zero-tolerance approach in penalizing and/or prosecuting police officers who kill unarmed, nonviolent, and non-resisting individuals in an arrest. The anger and frustration we feel at this moment must be channeled into working towards a better future for us and a future generation, and for future generations to come. For far too long we have marched, we have protested, and we have mourned our lost ones as the world and our allies watched on. It's time to stop watching and take action. What we're demanding is a ban on the use of knee holds and choke holds as an acceptable practice for police officers. The use of force continuum for any police department in the country must ensure that there are at least 6 levels of steps with clear rules and escalation. Each state's Open Records Act must ensure officer misconduct information and disciplinary histories are not shielded from the public. Recertification credentials may be denied for police officers if determined that their use of deadly force was unwarranted by federal guidelines. And lastly, implementation of citizens review boards in municipalities to hold police departments accountable and build public confidence. So, if we look at this, there are 2 main conditions that the NAACP is asking for. One is a call for the United Nations to classify the mistreatment of black people in the United States by the police as a human rights violation. And 2, the federal legislation mandating a zero-tolerance approach in penalizing and or prosecuting police officers who kill unarmed, nonviolent, and non-resisting individuals in an arrest. And additionally, there are a couple of specific procedural changes outlined as well. There are 4 of them that are like a ban on the use of knee holds and choke holds, police departments ensuring that there are at least 6 levels of steps on the rules of escalation, officer misconduct on information and disciplinary histories are public, and officers may be denied recertifications for violations if they use in violations of use of deadly force, and creating a citizens review board. So let's break it down and look at each of those 2 conditions. Now, as to the 4 procedural changes, I don't think I'll have much to say to them, just because it's going to be a very long panel pondering if that's the case. I think there's some discussion that we could have about each of those. I think there's some good ideas like the bans of the use of knee holds and choke holds, but I can also see the counter argument of those that the use of them isn't inherently bad. It's a placement of the use of them. For instance, knee to the back is actually a way to keep both sides safe from further escalation, which then that leads into further discussion of training, usage rates, etc. All those things that would make this a very long panda pondering. But I digress. I'm going to concentrate really on the 2 main conditions that are outlined by the NAACP's Instagram post. So getting back to the conditions, the first condition is to have the UN classify the mistreatment of black people in the US by the police as a human rights violation. So breaking this down, probably some questions are, can the UN do this? What precedents have the UN done that's similar to this? And what would that mean? So can the UN do this, and would it do this? Yeah, there could be a possibility. If a case could be made that there is a genocide of black people in the United States by authoritarian power, then there would be a cause for the UN to step in. Like an example, it might be like the case of Myanmar, in which they deem that 6 generals should be prosecuted for the genocide against the Rohingya Muslims. I butchered that, I'm so sorry, but anyways, technically there is some intersection with war crimes in that case, but the fact remains that the United Nations Human Rights Council stepped in without vote, by the way, and recommended sanctions against Myanmar. There could be similar regard in this case without vote if, and that's a big if, there is deemed an urgent enough matter, that this is deemed an urgent enough matter. It could also happen with a vote if the remaining countries of the Human Rights Council were to agree and to adopt that resolution as well. So just a note, the United States is not part of the United Nations Human Rights Council. They pulled out in 2018 in support of the ongoing partisanship of the council against Israel, while continuing to ignore the rights of violations of North Korea, Iran, and Syria. So if the UN were to resolute this, as an example, what would that mean? Would this be an effective a means of solving the issues of systematic racism by the judicial system and law enforcement in the United States? I'm not sure. It would be an interesting step, as it would bring the U.S. into a potential platform of international criticism. Excuse me. But I think we have to remember that the UNHRC can only make recommendations and do formal investigations. As we've seen with areas like North Korea, you can investigate all you want, but they don't have to listen. If we haven't taken action to resolve the severe human rights violations within North Korea by now, then we are left to wonder how much authority does the UN actually have to change things. And secondly, China was allowed into the UNHRC this past April 1st, 2020. Yes, I know, that's April Fool's Day. It's kind of ironic. But China has been amongst one of the highest violators in this world of human rights when it comes to labor and the enslavement of its own people. Just take a look right now at Hong Kong. Even today, there are still factories operating in sweatshop methods, and with all that's going on with the police brutality and the army getting involved in Hong Kong, I don't know how you make that case that they shouldn't have sanctions against them. Yet nothing's being done. Now, don't take what I'm saying as pointing out that it's criticism against a proposal, to have the UN classify the mistreatment of black people in the US by the police as a human rights violation. I think it's a valid request and one that potentially should be done. But what I'm pointing out is that if we want things to change, this in and of itself will not solve the problem, especially considering the ineffectiveness historically of the UN to have matters resolved globally. Now, the second condition is have federal legislation that is mandating a zero-tolerance approach in penalizing and or prosecuting police officers who kill unarmed, non-violent, and non-resisting individuals in an arrest. So I want you to first be aware that we actually already have a law in place for this. Under the U.S. Code of Laws, we see in Section 242 of Title 18 that it specifically forbids and makes it a crime for a person acting under any color of law, meaning official law enforcement capacity included, to deprive a person of a right or privilege protected by the Constitution or laws of the United States. What this means is that they cannot act beyond the bounds of their official lawful authority, period. This doesn't even have to be motivated by an animus towards race, color, religion, sex, handicaps, familial status, or even national origin. And when it talks about depriving a person of a right or privilege, it does include bodily injury results, which include death, from acts committed in violation, which include the use of, the attempted use of, or even the threatened use of dangerous weapons, explosives, and fire, as well as abuse, aggravated assault, attempts to kill, etc. So you're probably wondering, wait a minute, if that's actually in the United States Code of Laws, why do we have all of these cases of police brutality and deaths of black men and women with officers who are not being prosecuted? Because it's not that we don't have laws to protect those vulnerable. It's that we have contradictory laws that aren't made to be contradictory, but end up being used that way. You ever heard of court cases where a lawyer uses a loophole that really isn't the spirit of the law, but it is used in an alternative way and it helps their client get off? Well, there's something similar to this for police officers. You see, there's a legal document called the qualified immunity. And under the doctrine of qualified immunity, public officials can be held accountable only insofar as they violate rights that are clearly established in light of existing case law. This standard shields law enforcement from innumerable constitutional violations each year. In the Supreme Court's own words, it protects all but the plainly incompetent or those who knowingly violate the law. But you see, the QI was made for a purpose, and it wasn't the purpose to help public officials be unaccountable for the actions. Instead, it was created so that public officials couldn't be inundated by frivolous lawsuits. In other words, it was a process to help keep officials from being harassed. Imagine one way that you can get law enforcement to be ineffective if you're a criminal is to continuously file barrages of frivolous law proceedings against officers so they're bound up in court and unable to be actually out there doing their jobs. That was the intent of qualified immunity. So why was this law even necessary? Well, in the Civil Rights Act of 1871, Congress gave Americans a right to sue public officials who violated their legal rights. In Section 1983 of the U.S. Code, Congress said that if a public official violates your rights Whether via police brutality or an illegal search or unlawful arrest, you can file a lawsuit to hold that public official financially accountable for their conduct. Unfortunately, what preceded was a series of legal cases which created a logjam in the courts of frivolous lawsuits which had to be given due process and were eventually thrown out because of the illegitimacy of the claims. So in 1967, the Supreme Court invented qualified immunity to help protect the modest exception for public officials who acted in good faith and believed that their conduct was authorized by the law. However, QI, as I'm going to kind of call it, continued to get expanded abuse of the interpretation of that protection to where in 1982, in the case of Harlow versus Fitzgerald, they had changed it to protection of officials regardless of whether they were acting in good faith. And how they did it was to establish the burden of proof be switched to the victim, that the victim now had to show that their right was clearly established and that they must point to a previously decided case that involves the same specific context and particular conduct. And unless the victim could, then the officer would be shielded from liability. See, this is what it's been mutated to. Today, an officer who knowingly violates someone's constitutional rights will generally be protected from suit unless the victim can identify previous judicial opinions that address the specific context and conduct. This is the problem from the legal standpoint. It isn't that we don't have laws to protect the vulnerable. It's that we have a Supreme Court doctrine that was created for another purpose that is now used in an abusive way that was not the intent of the doctrine to begin with. When the NAACP is asking for legislation, I wonder if specifically targeting qualified immunity might be the best option, because then it would unleash the ability for accountability through the legal process of law enforcement violators. Just something to think about. And again, I'm not saying that it will solve all the problems, and I'm not saying that this is the right course of action. This is just my pondering of maybe what could work. I think it's just one avenue to look at if we're talking about legislation reform. Now, I also know that I said I wouldn't necessarily talk about the 4 procedural demands, but I'll add this. You can research what those demands mean and critically think through the impact of those 4. But what I do know is this. What we're trying to address, or what I believe the NAACP is trying to address, is avenues to reduce or remove the possibilities of abuse from police officers. Now, I saw this one post by Mayor Tim Sandoval of Pomona, California, and he identified 8 actions through the organization of Campaign Zero that police departments can take to decrease unnecessary violence. Let me show you what they are. So he identified that these 8 actions are, number 1, ban chokeholds and strangleholds. So this is similar to that of the NAACP's first item on their list. Second was to require de-escalation as a primary objective. Third was to require that law enforcement issues clear warnings before shooting. Fourth is require officers to exhaust all alternatives before shooting, and that it's not like a shoot first kind of type thing. The fifth is require the concept that their duty is to intervene. And then the sixth one is to ban shooting at moving vehicles. The 7th one is require the use of force continuum. This you also notice was part of the second procedural demand from the NAACP's list as well. And the 8th is require comprehensive reporting. What they found was with these 8 actions, Campaign Zero identified that if these reasonable actions were taken by police departments, that there can be a decreased risk of police violence by 72%. Now, I'd like to also say this. Yes, I'm advocating for these actions to take place, and I do fully understand that this places a huge burden on law enforcement. I'm not blind to the fact that by doing this, we're putting the lives of law enforcement officials at increased risk and harm in dangerous situations. And at the same time, there's cause for the responsible party to be the ones who are in authority to take the burdens when these issues arises. See, with authority comes responsibility. And as much as I stand with my black brothers and sisters who are fighting against the injustice of these murders by certain police officers, I also stand with the just and good police officers, of which there are a majority amount of. And I'm heartbroken over the countless law enforcement officers that have been killed in these past few days from violent rioters and looters. It's a problem. It's all a problem. This all has to stop. Not the peaceful protesters, but the violence on both sides. It has got to stop, or else we're going to implode ourselves as a nation. This is why I'm for reform. But I want lasting reform. And that is and always starting with the heart. You can't legislate morality, but you can help to be a bridge to changing hearts and minds. So when we're looking at all these things, and we're seeing why are the protests happening? Why are we protesting? Why is issues coming up in this fashion? What's the purpose of doing all this? It's to have a future that's worth having, and we need to make conscious self-judgments on whether our actions are creating more divide or actually bringing resolution to the issues at hand. I get the anger. I get the rage. And in the anger and the rage, let's not lose the focus on why we are angry and why there is rage. It is because we want things to change for the better. And not all the time is tearing things down the way to go. Now, tearing things from a systematic standpoint, sure, I can understand that. But when we start tearing people down and people groups down, that's the same spirit that which we're going by. I hope that we're looking at each and everything like these next steps in these areas and seeing and judging from a standpoint of, will they get us to where we want to be? And I hope we will, because I think it's an important enough issue for us to do so. So once again, this is Panda Ponderings with Phil, and I hope this gives you something to ponder about. Take care. Be informed. You have choice and you have responsibility. God bless.